How's it going, everybody? This is Attorney Anthony Miranda with the Firearms Policy Coalition. Today I want to bring to your attention the recent settlement agreement in Sharp v. Becerra, a case filed on behalf of California gun owners back in 2018 against the California Attorney General and his staff over their failed assault weapons registration system that resulted in potentially tens of thousands of people being turned into felons literally overnight. In 2016, through the enactment of Assembly Bill 1135 and Senate Bill 880, the California legislature expanded the Assault Weapons Control Act to generally prohibit the new acquisition, transfer, or possession of what became known as so-called bullet button assault weapons. Under the change statute, the state required assault weapon registration of the firearms or reconfiguration into non-assault weapon status to be completed by July 1st of 2018. Because of this, the individual plaintiffs in Sharp and many others around the state were unable to access the system to comply with the law, even though they attempted to do so multiple times and after having sought help from the state DOJ to do as much. Firearms Policy Coalition joined with Firearms Policy Foundation, California Gun Rights Foundation, then named the CalGuns Foundation, Second Amendment Foundation, and the Madison Society Foundation, as well as the individual plaintiffs, sued the state of California for violating their right to due process of law. In October of 2018, the state filed a motion to dismiss this case, but the court denied that motion, moving this case forward to a trial or a dispositive motion. In his opinion denying the state's motion, Federal District Court Judge England stated that defendants' own policies can support a finding of deliberate indifference. Now, I'm really happy to announce that on March 17th of 2021, the parties reached an agreement and submitted it for approval from the court. Here are some of the key settlement terms. First, FPC was able to get public notice and notice period that otherwise is not required in the statute at issue. The DOJ must implement a public notice period for at least 120 days from when the stipulated injunction is entered in by the court. Then the DOJ will make available a web page for new eligible registrations, which will remain open for a period of 90 days. This will be the registration period. Second, for the duration of the notice period and registration period, the DOJ must abstain from prosecuting individuals for the charge of possession of an unregistered assault weapon if the person satisfies the registration requirements by the end of the registration period. Third, anyone eligible to register under the registration requirements will be given protection under Penal Code Section 30680 and may raise their eligibility as an affirmative defense to any and all prosecutions throughout the state for which the valid registration of an assault weapon is or may be a defense. The California Attorney General must also inform all district attorneys' offices, sheriff's offices, and other law enforcement agencies in California of the stipulated injunction and consent decree, and advise that all pending investigations and prosecutions for Penal Code Section 30600 and or 30605, for which a valid registration of an assault weapon is or may be a defense, should be stayed or postponed if there is reason to believe the subject would be able to meet the registration requirements and register the firearms appropriately. Once proof that a person has successfully completed the registration requirements, any pending investigation or prosecution must end and any pending charges must be dismissed as to those violations. Also, anyone who has a firearm being detained or held by a law enforcement agency and who is not otherwise prohibited from owning or possessing firearms will not be barred from registering that firearm if the person is otherwise eligible to register the firearm under the registration requirements and can satisfy the registration requirements during the registration period. Finally, the California DOJ must pay plaintiffs $151,821.42 for attorney's fees and costs accrued while litigating this action. Despite California knowing they clearly failed to put in place an effective process to register the firearms, they still decided to litigate this case. To be very clear, FPC opposes registration of firearms and registration requirements, period. The issue in this case is that the plaintiffs and many others were made into felons because of the state and its failure to not even give an opportunity to avoid potential felony prosecutions and incarceration for a violation of the state's unconstitutional laws. The main thrust in the Second Amendment fight in California is FPC's direct Second Amendment challenge to California's assault weapons ban in the lawsuit Miller v. Becerra, which is fully briefed and now pending a trial ruling by Judge Roger T. Benitez in the Southern District of California. In other words, FPC's goal is to strike down the entire assault weapons ban in California. The settlement in Sharp is designed to protect California gun owners as much as possible while we address the broader Second Amendment question in Miller. Please head on over to joinfpc.org and join us in the fight against assault weapons bans and our Miller v. Becerra case. Your donations go directly to helping our team fight against these 2A infringements. Once again, this is Attorney Anthony Miranda with the Firearms Policy Coalition. I'll see you guys next time.